Hi, everyone. My name is Imran Ahmad. I'm a partner here at Norton Rose Fulbright Canada. And as we have every month, a special guest today, David Seevaratnam, one of my colleagues from our knowledge management team, who will be providing us an update in terms of what has happened over the last month in the area of privacy law in Canada. So, welcome, David.
Thanks, Imran.
So interesting month and a little plus with the holidays. A lot of developments, and I think what we want to do is maybe kick it off with the Federal Office of the Privacy Commissioner, which started the year with a series of announcements, and one of them was their strategic plan, and the other one is with respect to this biometric consultation that's ongoing. Can you talk us through sort of the two items there and what's unique about them?
Yeah, so the strategic plan was published to cover the years 2024 to 2027. And that document sets out three strategic priorities for the OPC in that period. The first, protecting and promoting privacy with maximum impact. Second is addressing and advocating for privacy in this time of technological change. And the third one, which you've seen the OPC mention a few times now, is championing children's privacy rights. And so similar to the biometrics consultation, is actually a feedback mechanism here. They want stakeholders to help inform how that plan is implemented. So you can email or complete the feedback form that's available on the OPC's website until March 31st. And the OPC's biometrics consultation, which we've talked about a couple of times, launched late last year. And in January, the OPC announced an extension of that consultation until this coming Friday, February 16th. So there's still a few days left to provide comments on the draft guidance that the OPC has posted.
That's a good point you mentioned about the biometric consultation. I think that's an important one. We're going to see an increase in that area, both in terms of international regulation around it, but also guidance that we do need for businesses to be able to implement these biometric technologies across the board. And right now, there are a bit of a mishmash of guidance documents that are out there, not just federally, but provincially as well. So I think it's going to be extremely helpful to have that. So for those who have not had a chance to make submissions to the Office of Privacy Commissioner, I strongly encourage you to do so. Second development is the coming into force of these AMPs, or administrative monetary penalties, under the Ontario Health Information Statute. Health information is super sensitive. It's an area that comes up a lot in terms of discussions with hospitals, clinics, and others who are operating the biotech and pharma space. What can you tell about this development to our audience here?
Right. So those regulations were, I'd say, long anticipated by a number in the health sector. So those are enforced now through regulations, the AMPs, as you mentioned, and the IPC now has discretion to issue AMPs as part of its enforcement powers for violations of the PHIPAA statute. So penalties are up to a maximum of $50,000 for individuals and $500,000 for organizations. The IPC has published a guidance document for the health sector on its website. So it intends with these AMPs to target things like snooping in health records, accessing or disclosing those records for economic gain, or denying people access to their own records. So the IPC is going to come out right away, hoping to give some guidance on how they're going to exercise this discretion.
Super important document, by the way. I mean, at the end of the day, although penalties are always on people's minds, typically it's not the first thing that any regulator wants to implement. So there's a bit of a gradation and factors that are taken into consideration, kept in mind. I think it's important to review this, and as an organization that wants to be responsible, make sure that we're following those guideline documents, but more importantly, making sure we can avoid those AMPs, inadvertently or intentionally. Third
Exactly.
point, third development, interesting. Always, whenever you put the word Google in any case law, people pay attention. So there's a case out of BC. What can you tell us about this new case that we've been tracking for us?
Yeah, so this is a recent decision out of BC's Court of Appeal versus Google. It's a proposed class action, and the plaintiff's claim concerns Google's alleged conduct of using facial recognition technology to collect and store facial biometric data without consent. So it uses this data in Google Photos for its face grouping function. So a lower court in BC had dismissed the class action, holding um, that it was very specifically about Google collecting biometric data for the purposes of this face grouping function. But
Hmm.
the Court of Appeal here said that no, the claim is actually much broader than that, and to properly characterize it, you have to see it as a violation of privacy involving this intrinsically private, sensitive data that there wasn't consent to use, collect, or disclose. So the court on appeal saw viable claims being pleaded under BC's privacy legislation, as well as potentially the tort of intrusion upon seclusion. But on that latter point, they left it open because that common law tort hasn't yet been recognized in BC. So there needs to be further consideration of that point.
Right, right. And is there any news yet if this case is being appealed at any level now?
I think well, we'll have to wait and see what Google does next. Yeah, I don't I haven't heard the next steps.
Yeah, it seems like whenever we talk about biometric, we were talking about this earlier in your first point about the OPC's consultation. Seems like everybody is very focused on it, and focused rightly so because it's very intimate, right? Your fingerprint, your face, your digital, retina scan or voice recognition. These are all biometric identifiers. Once potentially compromised or not appropriately collected, and then further process can never be really put the genie in the bottle back right at the end of the day. So it's a tricky one to make sure that where everybody's comfortable with it. Great. That's all the time we have today, David. My sincere thanks for being concise and to the point and leaving it to only three key developments, which is always hard. There's a lot going on when we come back in January. So that's our wrap up for the month of January. For those of you who are listening, feel free to send David or myself a direct message if you'd like to be on our weekly mailings. David puts this excellent summary together of key developments, both in terms of case law and current affairs related to all things privacy. It's fantastic, and a lot of our clients have appreciated the insights that David has shared with them on a regular basis to stay on top of all things privacy. And with that, David, thanks. We'll see you next month.
Okay, thank you.